We start this evening with the latest on the Howard Frankland Bridge stabbing case as the man accused claims self-defense. You're watching 10 Tampa Bay at 6. I'm Dave Wagner.
And I'm Courtney Robinson. Attorneys for Patrick Scruggs are asking a judge to throw out his charges. The former assistant U.S. attorney admits that he did stab the other driver, arguing he thought that driver was drunk and he was protecting everyone else. The victim says he had a medical emergency at the wheel when he hit Scruggs' car and then woke up to someone stabbing him. A hearing is set for May 16th for the judge to make a ruling. The Scruggs case is one of many in our area where stand your ground has been argued, in some cases successfully, and others where the immunity is denied. Those same cases are often presented to a jury as self-defense.
10 Tampa Bay's Eric Glasser takes a look at a few of the recent high-profile cases.
Well, Florida's Stand Your Ground law, passed in 2005, states that people can use deadly force in self-defense without having a duty to retreat, as long as they're not engaged in any unlawful activity and they are in a place where they have a legal right to be. It essentially expands the castle doctrine, which protects people from intruders inside their own homes, to include a wide range of situations where they reasonably believe that they are in imminent danger of death or great bodily harm.
They, in essence, have to put themselves into the shoes of the individual.
Was the use of force reasonable for that person under those circumstances?
The legislation was passed to allow an individual who is just defending themselves to avoid the whole process of going through the criminal justice system.
Stand Your Ground immunity, which also shields a defendant from civil liability, is granted more often than you might hear about, since no charges are filed in those cases.
There are plenty, especially even all the way down to misdemeanors, where defendants are raising the issue of stand your ground that just no one hears about.
The immunity, however, is not always granted and not always cut and dry. High-profile cases include Pasco movie theater shooter Curtis Reeves, denied immunity, but ultimately acquitted. The same more recently for Tampa dog park shooter Gerald Radford. But Clearwater convenience store shooter Michael Draco was denied immunity and was convicted, as was Trevor Dooley, who shot and killed a Valrico man during a fight on a basketball court.
Absolutely. You don't know which way it's going to go.
Win or lose, a Stand Your Ground hearing also affords a defendant appeals that they might not otherwise have been entitled to, and a rough idea of how things might go if their case went to trial, since much of the same evidence and witness testimony is presented. In Tampa, Eric Glasser, 10 Tampa Bay.
And although Stand Your Ground has now been around for about 20 years, it was modified in 2017, shifting the burden of proof to prosecutors. Now the state has to prove why a case does not meet the legal requirements. Previously, that burden was up to the defense.